Gentleman is recognized.
Thank you, Mr. Chairman. And I'm going to try to squeeze in here, or perhaps on yielded time if I don't get it all done, because I want to have a constructive engagement on this bill. I want to support this bill. But there's a very substantive inquiry I need to make about it. I hope someone on the majority side will be willing to engage with it. But the first thing I'm going to do is attempt to get out some of what the chairman would not entertain as a point of inquiry about the need for Attorney General Garland to return to this committee. And here's what I want to add to what has already been stated. Well, let me recap a couple things. It is the last 24 hours since a whistleblower has brought forth an email from the Counterterrorism Division of the FBI talking about threat tagging incidents where these parents are protesting against school boards. If that does not shock everybody on this committee, you've been in Congress too long. And so here's the other thing. That document that had to come out from a whistleblower was sent on October 20, the day before Attorney General Garland testified before us. That document should have been in our hands when we asked Attorney General Garland questions. Because on October 7, immediately seeing that October 4 memo from the Attorney General was breathtakingly problematic, I sent a letter and said, I want to see all correspondence within the Department of Justice connected with or relating to that October 4 memo. It should have been sent to my office the same time it was sent to the FBI. And believe me, there would have been questions to Attorney General Garland based on that. Not only is there a question about whether Attorney General Garland denied knowledge he must have had when he testified to this committee, but that memo was out. It was disturbing enough to an FBI agent to become a whistleblower. It should have been in the hands of Congress. This is a cover-up at the Department of Justice. Now, as to where we are in this bill, here's the problem that concerns me about the bill, and I otherwise will support it if this is fixed in some way. There is a definition, gosh, I hope I haven't paged away from it. There is a definition of sexual harassment here that is new to the law. Anyone who's practiced in this area knows that sexual harassment, the definition of sexual harassment is actionable under federal law, under Title VII, has been dealt with very comprehensively and carefully by the Supreme Court of the United States. In the Harris versus Forklift Systems case in particular, Justice O'Connor made clear that it must be sexual harassment is actionable if it is sufficiently severe or pervasive to alter the conditions of plaintiff's employment, and that requires that it be an objectively hostile or abusive work environment that's created when a reasonable person would find it hostile or abusive and the victim subjectively perceives it as such. Now, that's been the law. Harris has been the law since 1994. It's based on Meritorious Savings Bank, which has been the law since '83. Upending that is very concerning. The definition of sexual harassment dispute here that gets exempted, carved out, and would make pre-employment arbitration agreements unenforceable includes, without any definition of that, without any language relating to the standard of the severity, whether it has to be offensive to a reasonable person and so forth, it simply says, for example, one of the things in there is unwanted sexual attention, including unwanted sexual comments and proposition for sexual activity. This leaves open the possibility, it seems to me, that you're ditching the reasonable standard test so it could be as subjective and as varied as the variety of people in the United States. Is it intended to dispose of that standard? And if not, why is it done this way? And I'm about out of time, but I hope that someone on the majority side will, yes, I'd certainly yield.
Thank you. I believe you're referring to